This meeting of the Veterinary Medical Board to order. Anne Marie will call roll to establish a quorum.
Dr. Waterhouse?
Present.
Dr. Sullivan?
Here.
Kathy Bowler?
Here.
Jennifer Laredo?
Here.
Dr. Nolan?
Here.
Dr. Nunez?
Here.
And we do not have Judy Mancuso or Alana Yanez with us today, but we do have a quorum.
Thank you. So I'd like to thank everyone for coming to my neck of the woods. For those people that flew in, I hope you enjoyed the sequoia trees in the lobby of the airport. And I hope you enjoy your couple days here at the zoo. If you walk around this way and go down farther down the path, you can see elephants. And if you walk around this way and walk farther down, you can see more antelope, and you can feed the giraffe and see all sorts of things, including the baby rhino. And there's a baby lion out in this exhibit right here. Do any other board members have any comments?
Thank you for having us.
And we will be holding, just so you know, in case you were wondering, going through the agenda, we will be holding elections for officers in February. We're not doing it this meeting, we're doing it in February. And at this time, would any members of the public like to introduce themselves? This is voluntary, but if you'd like to introduce yourselves.
Cindy Sabley, RVT, Central Valley Vet Tech Association, and also an CBMA RVT.
Leah Schuko, CBMA RVT Committee.
Grant Miller, CBMA.
Ralph Maker, CBMA.
Jeff Monica, President of CBMA.
Leslie Boudreau, Carpenter. Nancy Early, Carpenter.
Dr. James Sims, California Physical Therapy Association, and consumer.
John Klingberg, MDC. John Pasco, UC Davis.
Diane Sokoloff, liaison to the Veterinary Medical Board from the Attorney General's Office.
Ethan Mathis, Med.
Kurt Supervising Attorney, Consumer Affairs.
Candace Ring, Veterinary Medical Board.
Bonnie Woods.
Brian Yerger, University of San Diego School of Law.
Thank you. And so, first on agenda item number 3, we will look at the minutes from our last meeting.
Ethan distributed a new document that should have been in your pile this morning. There were a couple of motions that we amended from the board meeting, and they were the motions relative to the votes on the regulations. So if you want to pull out the amended document, I believe they are in underline so that you know which changes have been made. Yes. So if you look at page 3, you'll see the underlined text.
Oh, I get it.
Again on page 4, and so on. So everywhere where there was a regulatory motion made by the board, the language that is underlined is the correct text.
Okay. So let's start. So that's on the amended. But starting on page 2, does anybody have any corrections? I have in the last paragraph on page 2, Dr. Sullivan, I wanted to ask you about this. The way it was written is, in the first sentence, last paragraph, noted there appears to be a push within the industry, but I think what you were getting at was there appears to be a push within a small segment of the industry.
Yes.
Not the whole industry.
Or is it the industry, or is it, it's not the veterinary medicine medical profession. It was other industries that are pushing for a telehealth type model.
Yes.
What would we call those industries, Dick?
It is part of the profession.
Oh,
But
okay.
it's a small segment of the
Very small,
Okay.
but very powerful.
So we'll say small segment of the profession.
And I would say a virtual exam, to be specific, because there's absolutely no problem with telemedicine. It is the specific part of having a virtual exam to satisfy the VCPR.
Okay, so what we would say then is within the small segment of the profession that proposes authority to conduct a virtual exam.
To establish a VCPR by a virtual exam.
Okay.
Anything else on page 2? On page 3, second paragraph, last sentence, Dr. Sullivan opined there's some flexibility to the regulation as written, and that is clear. I think it would be better served to say, and that it should be made clear.
Yeah.
A VCPR needs to be established first. Anything else on page 3?
There's a paragraph that's in bold text. It says C. The paragraph below that, the fourth line, there were compliance issues identified in the board's review.
Oh,
The first
identified.
should be striked out.
Thank you.
Anything else on page 3? Okay, page 4. Page 5. And just so you know, on the last paragraph where it talks about doing a survey, and there hasn't been enough data yet to do anything with that, but yeah. Okay, page 6.
I had a question on the comment about down in 11, second or the third line where it's talking about elimination of the VLE would have an impact. Does it have an impact on the university licensure? Are they required?
Yes.
They're
Yes.
required to do the VLE?
Yes.
All right.
Page 7. And page 8. Anything?
Can I ask a question on page 7 for a moment? Just because it reminded me, maybe it's in the last major paragraph on page 7, where Mr. De La Cruz was going to provide information on comparative boards and peerages. Did we follow up on that? Is that going to come up in the agenda? Because I meant
He has resigned his position.
Oh.
So we're waiting for the new person to take that position and get organized. But
Okay.
so it's not going to happen at this meeting.
Okay, thank you.
Okay, page 8. Nine. Ten. Anything on 11? Or 12? Are there any comments from the public? Okay. Take a motion to approve the minutes?
So moved.
Second.
Okay, we have a motion and a second.
Okay.
Call the roll.
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nunez?
Yes.
Dr. Nolan?
Yes.
Motion carries. Okay, agenda item number 4. Review and approval of the board and committee member administrative procedures manual. It actually was good to have us go through and read this again. Section, go through this.
Well, I think what we can do is, no, I don't think we need to, because the board's approved all the other language that's been in this manual in the past. So really what we're asking for is the board to look at the changes that we've made. This manual's been approved by the board, and anytime there's changes made to the manual, it's brought before the board again for update. I will make a couple of comments that Cheryl pointed out, Dr. Waterhouse pointed out, and that is any place where it says NBVME needs to be changed to the ICVA. So we will make those conforming changes. There is also a reference in the back of the manual to the RVTC. That committee is no longer in statute, so we will remove, it's page 22 of your document if you're following along. It's just a reference to abbreviations and acronyms. We'll remove the RVTC and again update anywhere where it says NBVME to ICVA. So specifically, the changes that were made to the board member administrative manual, administrative procedures manual, are in relationship to how we appoint our multidisciplinary advisory committee members. So we were asked to incorporate within this manual a process by which we would identify, select, and appoint new multidisciplinary advisory committee members. So on page 17 of your manual, there's some suggestions. We intentionally left in the comments between Tara and I as we were trying to really formulate a process that gives the board an opportunity to first see the letters of interest, the resumes, and then after reviewing the documents, schedule in-person interviews at a later date, a later meeting. In working with Tara on this, she suggested perhaps the board may want to consider establishing an elections committee. And the purposes of the elections committee, and this is done in other boards, is so that 2 members of the MDC can go through each of the applications and conduct preliminary phone interviews. This also gives me an opportunity to work with those 2 members if there are any enforcement issues that I need to discuss with the members, because I wouldn't do that in a public setting and before all board members. They shouldn't be privy to all that information.
Enforcement issues with the applicants?
With the
Yes, with the applicants, yeah. So it doesn't preclude the full board from necessarily seeing the applications or letters of interest, but what the charge of the elections committee would be is to conduct preliminary interviews via telephone and then select 2 or 3 candidates per position that would come before the board at the next scheduled board meeting to be interviewed by the full board. Yeah, I think we should, yes.
And can I ask a question?
Sure. Yes, some
Why-
discussion on this.
Why did you choose 2 members of the MDC to be on the election committee?
I'm sorry, 2 members of this board.
Okay.
I apologize, that was incorrect. 2
Okay.
members of the Veterinary Medical Board would serve as the selection or election committee.
Okay.
Yeah. And that really gives me an opportunity to have open dialogue with those 2 members. If in doing the background on the applicant, there are enforcement issues that are relevant to whether or not this person should be selected.
Do you think that one of those members should be the RVT rep?
So,
Or,
I think
or
Tara and Emery had talked about the president, vice president, and EO being on the elections committee.
because if it's just 2, there's 3 categories of members on the
Yes.
board: public, RVT, and DVM.
Yeah.
So maybe there should be 3 on the election committee.
We
But
can't
you
do
can't
that.
do that.
Can't do
We're in a
3.
public meeting. Yeah, that's the problem.
Dr. Sullivan?
Yeah, I think 6 months is not adequate. Right now, we're talking about this and getting applications in at 9 months out, and I think that we should do at least that. I think the idea then is, once the election we've done the election, then the new members can sit in on at least one meeting before they take office, take the position. So I think 9 months would be a more workable time frame.
Okay, so we can change that. So on page 16, recruitment efforts for upcoming vacancies on the MDC shall begin at least 9 months prior to the expiration of the said term. For the purposes of this particular recruitment, we really should consider doing something in February because we have an RBT seat that absolutely needs to be filled, that can't go beyond the February meeting. But in the future, we would employ the 9-month lead time.
Correct.
Okay.
Yeah, whenever there's a vacancy, then it's automatic, we have to fill it right away.
Right.
So
Any other comments?
if we did the election committee, then on page 17, where it says the board shall select a candidate to be interviewed, that part would be crossed out?
Well, it's
Or
an option. So alternately,
You would keep it there,
yes,
but we would make the decision whether we would do an election committee.
correct. And that second to last sentence should say the selection of an MDC member shall be made at the board meeting. MDC members seeking reappointment are not required to be interviewed unless requested by the board.
So the election committee presents their recommendation at the next meeting.
Yes. So that if this proceeded, then Dick and Anne Marie and I would have a telephone conference call with each of these with standard questions. And then he would separately select 2 or 3 per position, and then have them show up for personal interviews at our next meeting in February.
And those will be interviews in front of the board.
Yes. And the entire board would be asking interview questions of the candidates, yes.
This wasn't in the policy before? This is on-
It's on there.
Dr. Sullivan?
Yeah, I would envision this happening. I mean, we would be doing this, but I think the only reason to narrow down the field is if we have 5 or 6 candidates. I'm not sure.
Right.
You know, if we have 3 candidates or 2 candidates, would be narrowing it down.
So, and so if we had, there are some boards where they have, 20 or 30 applicants per position, and that's just unwieldy. So that would be one reason if we did have a large number of applicants. And the other one is because of the enforcement aspect that Anne Marie talked about.
Right.
Right, so Dr. Sullivan, even if we're not necessarily making a selection of 2 or 3 candidates because we have a large population, it still provides me an opportunity to discuss with you any issues that I would otherwise be able to discuss in an open session.
It would save a lot of time, and it would be a fair process, I think.
Right. Well, I was going to say, this is not uncommon for boards to
No.
do for many positions, and I think it makes a lot of sense. And from a board member perspective, the one time we did it, for me personally, when we had everybody coming in, it was very good and informative, but it was still a little, I mean, it's hard to make a decision on the fly like that when you have really qualified people for various categories. So I think this makes sense.
So do we have a motion? Ask for public comment.
What's the
First of all, do we have public comment?
Can we
I
clarify?
motion to adopt it.
Can we clarify the language?
Which language?
The language that we're
Read the
adopting.
Okay, so starting on page 16, the language for the actual selection. Recruitment efforts for upcoming vacancies on the MDC shall begin at least 9 months prior to the expiration of said term. The board shall advertise, vacancies on its website and shall work with professional associations and other consumer groups to notify the public of the recruitment process. All new applicants seeking a position on the MDC shall submit a letter of interest along with a resume, CV, or both to the board. Upon receipt of a letter of interest, board staff will inform a prospective committee member perform a prospective committee member compliance evaluation to ensure that potential appointees adhere to California's various statutory and regulatory requirements. The board shall select candidates to be interviewed by the board at a scheduled public board meeting. Interviews may be conducted by telephonic means at the board's discretion, provided the telephonic participation is duly noticed on the meeting agenda. Alternately, the board may establish an elections committee comprised of the board president, vice president, and executive officer to hold interviews for the purposes of making candidate recommendations to the full board. The selection of an MDC member shall be made at a board meeting. MDC members seeking reappointment are not required to be interviewed unless requested by the board.
So this is either or essentially.
So the board could still choose to interview every applicant.
Right.
Yeah.
It sounds to me like this allows for only a telephonic interview. Is that correct?
No. Oh, the pre-screening is telephonic. The selection happens at the public board meeting.
But it doesn't make notice that they're in person.
We can add that. I mean, it does say at the meeting, but we can add in person for clarity purposes.
At the very end.
Right now, the language is just permissive in that the board may conduct by telephonic means. So you could do in person or by telephone. Okay. I also wanted to make a note that I just want to be clear that what this is two options with respect to how the interviews themselves are being conducted, not about who selects the candidates for interview. The board does that. That's the language. I just want to be clear that the options are just about how the interviews occur.
I thought we did that on purpose to have the telephonic option available in case a viable candidate was unable to travel here, right? Wasn't that the purpose of this? So it does basically allow or permit.
It does.
The telephonic. Just check.
The difficult part with doing it telephonically, and it is worth noting this in a public forum, is that the person who is participating via telephonic means would have to be at a public location where members of the public could join that individual being interviewed as part of the board meeting. So they can't do it from their home, they can't do it from their office unless they're willing to invite the public in. So we can't have a telephonic location that is not open to the public and accessible.
Dr. Sullivan?
Yeah, I think from this discussion, I think we need to remove the word alternately. Because if you're wanting the president, vice president, executive officer to review the candidates for background material, you have to form that committee to do that.
And you're right, if you want that, the board could say, we don't want a elections committee at all. This gives the board the option.
Okay, then how are you going to do the background checking without it becoming a public?
The way we've always done it, which is staff does it, and if it's not something that is a matter of public record, I don't say anything.
I think we should either have it or not have it. I
Okay.
think it should be spelled out and be a decision by the board to either do it or not do it, and not have it up in the air as to do it sometimes but not others.
Okay.
Well, that's what I originally asked, if we should cross out the first part, but upon Henry explaining it, it does give us the option to change it, or it gives us the option to do it either way. We probably will choose to use the election committee more often than not, but it would leave open the option for us to do it for the full board, being involved in all stages of the application and review process.
So what this motion would do is, it would do two things. It would insert this language into the administrative manual. It would also then serve to establish an elections committee. At some point in time, the board may wish to do away with that committee. But until they do away with that committee, there's an elections committee in place, and their function would be to do just that.
And here's another example. What if for some reason or another we don't like the president and the vice president, if it's like Donald Trump and Mike Pence, you know, and we don't want them to be as the nomination committee, then the board has the option to be involved in the whole process. Sorry for that example, I just had to do it.
Well, I want to make one clarification.
Had to bring
on
up
that.
Donald Trump right away.
Tara has a comment.
Typically, the board president has authority to establish committees.
It's committee.
So in this instance, it's a small committee.
I'm sorry, Tara, the acoustics aren't very good in here. I'm going to ask the public to keep quiet during the meeting, please. Sorry.
If the board has a board president and vice president that they don't typically agree with, that wouldn't really matter because the board president could establish the elections committee. We could write something in here to make it a bit more limiting that the board would have to specifically vote to establish the elections committee.
Well, when a position becomes open, wouldn't the board have, the way it's written, make a decision on which of these two options they'd like to go with? And if the board chooses not to have an election committee, then even though the president has the authority to create a committee, the way it's written, I think it's a safeguard that I'm in favor of keeping.
And then how would we get around the problem with disciplinary action then? Anne Marie?
Well, as I said, disciplinary action is a matter of public record, so the board would be privy to that information. The information the board would not be privy to is something that perhaps there's an ongoing investigation, there's been preliminary findings, and we don't have final resolution yet in a case. And this would give me an opportunity to not provide the committee members with any details, but to let them know that there's a pending issue before the board and it's under investigation. And that way the board could make a decision.
So there's a way around it. It's doable.
Sure.
Yes, Kathy?
I actually think it should be one way or the other, personally. It's cleaner, there should be one system.
I agree, but I need a motion.
Well, I think we have Diane.
Let me just, if you don't,
Yes.
if I may, I think there
Do you
might be-
identify yourself?
Yes, I'm Diane Sokoloff from the Attorney General's Office, Supervising Deputy Attorney General and liaison to the board. I just think there might be some Open Meeting Act issues here in terms of having a subcommittee of board members meeting. So
As
I
long
just
as
want
there's
to,
two board
it doesn't violate the Open Meetings Act.
I'm just raising that. I think there might be some
Oh, God, double whammy.
issues.
We need a compromise.
Yeah.
Whatever you're going to say is going to be bold, I know.
We're getting to the point there's too many attorneys in the room.
Good morning, Madam President, members, Kurt Epler, Supervising Counsel, Department of Consumer Affairs. Just on the language itself, I have essentially two concerns. Number one, where it begins alternatively, not on the merits, just on the OMA. The concern would be you essentially have a 3-member subcommittee. It doesn't really matter who those people are. To use hyperbole, it could be me, Masakloff, and somebody who's out there feeding the lions, and that would be required. That would trigger the OMA because it's 3. It doesn't matter who; it's the number. So it's not how many board members are on. It's not how many. It's you designate as 3.
Is the executive officer considered a member?
I'm not.
Yeah, that's what, she doesn't even vote.
Under this, it would be, because it says, may establish committee consist of the board president, vice president, and executive officer. That's the constitution of the committee,
So
subcommittee.
perhaps you leave the executive officer out of the language.
That was-
I still serve in a staff role where I advise the committee.
Thank you, Ms. Tillman. That was going to be my next comment, is my 15 years with Consumer Affairs, rarely, if ever, has, and I use the term not to be pejorative, a staff member been assigned to a committee. Usually their function is support.
That's
So it's more like changing the language.
Yes.
Yeah.
That would be helpful.
Thank you, members.
Thank you.
You got a double duty.
So I just want to point out, Mr. Hepler, yeah, I just want to point out quickly that there's other areas in the board member administrative manual, I think you were with us during this time, but where we have an executive committee. The executive committee shall consist of the president, the vice president, and the executive officer. So if we're going to apply this rule uniformly, which this is, I'm learning something today, then we need to remove the executive officer from the executive committee as well.
I will take my lumps, and I would concur. Like I said, I think there's two reasons. Number one is the constitution of the makeup of the committee from a numerical perspective. Number two, I believe, with all due respect, that you and the rest of the staff members should play the support role and not actually be
Named. Okay, thank you.
Okay.
So
So have we removed the EO from the elections committee?
we have.
And
That's good, but now we're back to the,
And we've also removed the EO from the executive committee on page 16.
Okay. I would like to motion to accept this.
And should,
As-
you want to read how you would like it
As
to be stated?
The only changes is that 6 months was changed to 9 months, and the executive officer was removed from the election committee.
Okay.
Since there are more changes to the admin manual, you could just do one giant motion at the end to accept, to revise the admin manual pursuant to the discussion and the agreement.
My only concern with doing that is if they didn't agree to both changes, I wanted to make sure that the motions reflect that they were, and really the other one is probably less complex and might be a little less controversial, but I just wanted to make sure we separated them, so if they didn't approve one, it didn't, by virtue of not approving the whole document, not approve the other.
Dr. Sullivan.
As this is written, the way I read it, it means that at every MDC appointment or election, the board would have to decide whether to have an election committee or not.
I understand that and I support that.
Okay, I don't. I think we should, as Kathy said, we either should have it or we shouldn't. I think it needs to be.
what would be the reasons to decide one way or the other?
I think it's a safeguard. I think why exclude that option? What's the benefit of having one or the other?
It's
just
just
other
clear.
than
It means
disciplinary.
that's the process. You do it. You don't have to, oh, I forgot to do it, but now I want to do it, and it's the next meeting, and it just firms up the
I
protocol.
mean, it's quite obvious when an open position is going to come up. It's not like it's going to be something that we're going to miss. We know when these positions open up.
Not when there's a
And
vacancy.
the only reason why I've been told not to have it one way is because of concerns about disciplinary issues, which Anne Marie explained can be gotten around.
I don't.
Kathy?
I was kind of thinking this was because, depending on the number of applications, but it really, I guess it can't be that, because this would be decided before the applicants come in, that we're going to use the alternative method of the executive committee or not. Now, we could define it as the executive committee could be triggered based on number of applications or something like that. But I still think it's confusing to have both in there. I agree with Mark. I like the open, I think, for everyone's sake. But I also agree that it's more efficient and maybe more fair to the applicants to do a interview.
So I think I have a good middle ground. What if we change the language to say the board shall establish an elections committee unless otherwise noted, and then go on with the rest? So it would actually, after we have selected, or upon receipt of letters of interest, board staff will perform a prospective committee member compliance evaluation to ensure that potential appointees adhere to the California's various statutory and regulatory requirements. The board shall establish an elections committee, and then go on to say comprised of the board president and vice president to hold interviews for the purposes of making candidate recommendations to the full board. Then it would be the board, the elections committee shall select candidates to be interviewed by the board at the scheduled public board meeting, and go on from there.
So then what you mean, unless otherwise noted,
Yeah.
means that the board shall select the candidates to be interviewed by the board at a scheduled public board meeting.
Right. Well, the unless otherwise noted is that the process would be to establish an elections committee.
Yes.
Unless otherwise noted, unless the board has an affirmative, there's an affirmative action taken by the board to remove that committee. That way you don't give up your opportunity to do that, and procedurally, there is an elections committee established comprised of the president and the vice president.
Dr. Sullivan?
I'm not even sure you need the as noted part, because what we're saying is this is an election committee, this is what it is, but whether they need to even have a meeting or not depends upon the situation. So I think we need to define that it's there, and then it's up to the situation to dictate whether they have a meeting or not. I think it needs to be defined.
Jennifer?
I like the idea of having the option. I agree with Dr. Nunez. In some cases, we're only getting a couple of applications, and there may not be the need to have the committee.
May I request that you second my motion?
I've also got another possibility, striking the word alternately and inserting upon a majority vote of the board may establish. That makes it really clear that the board has to agree, all the members, to establish the elections committee. I'm just concerned that a board president could read this to mean the board president can establish the elections committee without any input from the members, because that's typically what a board president could do.
Okay, that would work.
Okay.
So then the way it would read is all new applicants seeking the position on the MDC shall submit a letter, et cetera. The part where it says the board shall select candidates to be interviewed by the board will be crossed out. Interviews may be conducted, and then instead of alternatively, it would say upon a majority vote by the board, an election committee shall be established.
Dr. Sullivan?
We better start a year out, because if we're 9 months out, we ask for candidates, we get those applications in, now we're 6 months out, and now the board has to vote at a meeting to have a committee, and
That's
now
fine.
we're 3 months out.
That's fine. Yep, let's do 12 months.
So then why do, okay, I think it's cumbersome, and I just think it's not necessary.
Kathy?
I don't know whose mic is, but anyway, I just wanted to, just to not reinvent the wheel. What do other boards do that have numerous applications for committees? Maybe we can look at the way.
This did come from another board.
So this is what they do. They have the alternative.
Yeah,
They have
accountancy board.
Okay, and do they have a timetable so when they decide to use the executive committee versus the board? or-
No.
Yeah.
Okay. But it's worked for them.
Jennifer?
I just have a grammatical correction on the first paragraph on page 17, 1, 2, 3, 4, the fourth line up. the selection and MDC member. I think it should say selection of an MDC member.
Oh, yeah. No, I
Oh,
think
yeah,
it's
right
right here.
there.
No, that one I already made. She's talking about right there. Yeah, she said 4-1. Oh, I thought she was talking about 4-1. Okay. So, oh, yeah. Yeah, I have that one, Jennifer.
Okay, so Mark has a motion, but I think we need to restate the
Well,
motion.
no one seconded it.
Yes. But we've had several suggested changes there, so what?
Okay, so the changes are as follows. Recruiting efforts for upcoming vacancies on the MDC shall begin at least 12 months prior to the expiration of said term. And the paragraph would remain intact with the removal of the sentence starting with, the board shall select the candidates to be interviewed by the board at a scheduled public meeting, where the sentence starts alternately. It would say, upon a majority vote of the board may establish an elections committee comprised of the board president, vice president to hold interviews for the purposes of making candidate recommendations to the full board. The selection of an MDC member shall be made at the board meeting. So those are the changes.
So you're not striking the board shall select the candidates to be interviewed?
We are.
Yes.
Yeah.
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 Is there a motion?
Wait, Mark.
That's my motion.
Okay. Is there a second?
And I'll second it so we
Okay.
can discuss this.
Any more discussion from the board?
Yeah.
Any discussion from the public?
Hello.
Can you come
Hello.
forward, please?
I'm sorry. I just for the lawyer part of me, wants to just suggest that you're thinking about the fact that putting all of this requirements and such like that is going to require you to follow a specific structure and organism, and it's going to make your decision making more rigid in terms of having to follow something, as opposed to if you didn't have anything like this, there would be no requirements that you follow certain criteria. So I just wanted to raise that as just something to think about. You know, if this is something that you want, that's fine. But it's not something, I don't think it's something that is like a requirement. But if it's something that you want to require of yourselves, then that's something to
So
think
the board
about.
voted to have some criteria to the
Criteria?
selection of the MDC at their
Okay.
last meeting.
All right,
Yeah.
well, then this is a nice criteria.
Any other comments from the public?
Okay.
Any other discussion or call for the vote?
I have some discussion.
Yes.
I thought we were trying to make it easier for more applicants to apply to this. Is that, am I under a misdirection there? Because I thought that it was a burden for applicants to have to come all the way here for the interview process. And so we were trying to allow a part of the process to be done under teleconferencing.
This doesn't change that. So this adds that they can be
But it adds a lot
done.
more prescription than that. I mean, I
But the pre-interview would be done by telephonic means. It wouldn't require anyone to travel anywhere. That would be the phone conversation between the vice president and the president and the candidate as the pre-screening. The actual interview that's conducted before the board, there is language in there that would, well, no, there's language in there that allows that to be done by telephonic means, so long as that candidate is at a location where the public has access. They cannot do that interview. That's an Open Meetings Act issue. We can't remove that.
But this is adding another step
It
to
does.
the process.
It does.
And I wasn't sure where that idea came from.
Two things.
Was it, one of them was you were able to share
Yes.
more information, I understand
Yes.
that, but what's the other?
The other is so that if there is a number of individuals that have applied for the position A1 seat, say for example you have 10 RBTs applying for the RBT seat, It gives the vice president and the president an opportunity to go through and make sure those individuals have the breadth of experience, the qualifications to serve as a member of the MDC. So it basically provides a pre-screening, so at the time where you're doing a public forum and these people are being interviewed, you may have 2 or 3 of the top candidates before you. If you want to interview all 6 candidates, all 8 candidates as an entire board, that option's still there. That's how we've always done this. But this gives us the opportunity to do a pre-screening, and it gives me an opportunity to share background information that I couldn't do with the full contingent of
And
the
are
board.
we anticipating a onslaught of applications?
We have quite a few. We have quite a few RPT applications right now, and some came in last night.
Anticipating in the future, is this something that
We hope so.
have to worry about? Okay, it doesn't seem like it's been a problem in the past.
Yeah, but there are some boards that have 20 or 30 applicants for this position, so it could potentially happen.
Right.
And that's just unwieldy.
I'm anticipating an onslaught of applicants because everyone wants to be us.
And they know it.
I'm sure. But as you're considering voting for this, I do assume that the board will often choose the efficient route by doing the election committee. I don't anticipate this as being burdensome or making it more difficult for us to choose the members. I'm happy that it has the option for us to do other things if we choose to.
Thank you for the clarification. I just want to make sure I was on the right page.
Okay. Any more discussion? We'll call for the vote?
Okay, Dr. Waterhouse.
Yes.
Dr. Sullivan.
No.
Kathy Buller.
Yes.
Jennifer Laredo.
Yes.
Dr. Nolan.
Yes.
And Dr. Nunez.
Yes.
Okay, motion carries.
Before we move away from page 17, Mr. Hepler brought to my attention that there's under complaint disclosure, chapter 9 toward the bottom of page 17. It starts off with complaint disclosure. General complaints are not subject to disclosure. Because the board receives consumer complaints, but then also files complaints, I think we need to just clarify that it's consumer complaints are not subject to disclosure.
What complaints would be, aside from consumer complaints?
The complaint, well, first off, what's a general complaint? It's vague. What is
Well,
that?
I agree with you,
Yeah.
but why not complaints are not subject to disclosure? I guess I don't understand the differentiation between a public or consumer complaint and what's the other kind of complaint? An internal?
You said file complaint. What's a file complaint?
Effectively an accusation. So I'm talking about internally, staff refers to complaints received as the files themselves. So I think just to be clear, we could just change general to consumer. That's it.
Okay. Or if we did nothing and just said complaints are not subject to, that wouldn't fly?
I would think it's more appropriate to be clear by using consumer.
Okay, here's why I'm bringing this up.
Mm-hmm.
So oftentimes we receive information via, say, inspection or from some other source, not a consumer complaint. And we then, as staff, have to generate a complaint to investigate and continue with the process. So it may not be qualified as a consumer complaint unless you're going to include internal complaints as consumer complaints, because we wouldn't be disclosing our initiated complaints either.
Yeah, right.
So there are complaints that come out of things like advertisements for unlicensed activity that somehow come across our desk, or as I mentioned, we may find out that there's unlicensed activity going on via an inspection that occurs. We then have to generate a complaint internally because there's not an actual consumer filing that. Would that be considered a consumer complaint, or would it be?
No, I mean, because alternatively, we could just do all complaints
Okay.
against a licensee. that way. I'm
Right.
just trying to make sure that it's a little bit more clear than general complaints.
Okay, but it wouldn't be against a licensee necessarily either, it could be unlicensed. So I think if we're gonna make it, just complaints are not subject to disclosure, or if you wanna say all complaints are not subject to disclosure, I'm worried about using the term consumer.
Okay, how about all complaints received or generated by the board?
Okay.
I would agree with Anne-Marie, I'm sorry, because I think there's just too many words, and I think the word complaint is sufficient, and it's distinguished from, for example, an accusation or a statement of issues, which is a completely different term.
Diane, can you come forward, because I just don't think they're picking you up on webcast.
Sorry.
That's okay.
Just for simplicity, I would agree with Anne-Marie's suggestion that just using the word complaint is sufficient, because as she stated, there's complaints that are from the public. There are various types of complaints, still maybe against an individual who may or may not be a licensee. So I don't think it's ambiguous or vague, but it's also broad enough to encompass all the different types of complaints, and it's also distinguished from the moving documents that are brought against licensees or unlicensed people by way of a statement of issues or accusation or citation. So I just feel like it doesn't need to be so wordy, and that complaint would be sufficient, but that's my opinion. And also, with these kinds of things, I always like simple wording, because I think it makes you in much less hot water.
Speaking of,
I'm done.
Okay, so I think Diane's suggestion was to just leave it at complaints.
Okay.
Complaints are not subject to disclosure.
The next section that the board, we propose changes to, and this is really to comply with the government code, and it deals with petitions for reconsideration that are submitted to the board by the respondent. There was language that essentially allowed me to, as the executive officer, to issue a 10-day stay of the decision, but that language that was in the administrative manual prior to this change essentially allowed me to do that at any point in time, which is could be beyond my authority as the executive officer to just wave my magic wand and issue a stay. This says if there is additional time needed to evaluate a petition filed prior to the expiration of the applicable periods provided under the government code. So essentially, you're up against the expiration of the decision, and unless I do take some affirmative action to extend that, the petition will then the decision will then take effect by operation of law, and there will be no opportunity then for the respondent to request the board consider their petition for reconsideration of the decision. So this just clarifies what I have the authority to do under the government code.
Any comments? Is there a motion?
So, I motion to accept that change that Anne-Marie just explained, and just to clarify, did we cross out the word general?
Yeah.
And then I'll include that in my motion.
second.
Any other questions?
And then do we need to include the crossing out of the RDTC committee?
Yeah.
Yeah.
Conforming changes. Thank you, Mark.
All three of those
Conforming changes.
in my bold motion.
Any comments from the public? Call for the vote?
Dicted, yeah. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
Dr. Nunez?
Yes.
Motion carries.
Motion carries. Okay.
We are going to take like a 10-minute bio break. Yes, I need
We're taking 5 minutes.
5 minutes.
Okay.
5 minutes.
5-minute break.
Okay, moving on to agenda item number 5. So sorry, I guess we're still back on 4. Tara has some more comments on agenda item number 4, sorry.
Okay, so on page 20, we haven't discussed the modifications to the process of a denial of a petition for reconsideration. Here, we're just clarifying that in addition to the existing provision that a board can vote to deny a petition for reconsideration, the government code, the APA, can also authorizes the board to take no action on a petition, as well as when there are insufficient votes to reach a quorum in favor of the petition, both of those are also denials of the petition. So that's just a clarification of existing law.
Yeah.
So is that added then, the underlined part?
Yes.
Okay.
You're right, Dave. I forgot that part.
What's that?
I forgot that part.
Okay, is that any motion?
Tara, can Mark amend his motion since his motion was to adopt all conforming changes to include the change to page 20?
You'd
Or
have
should
to
just make a
reopen
new
the vote, which takes another vote to reopen.
Oh, so it's easier
Yeah,
just to, okay.
Okay.
Okay, so with that motion, then potentially include the modifications to the orders that are included.
Aren't those just samples?
They are samples, but they're part of the manual.
Oh.
I think they're referenced as attachments.
Okay.
So we've made some clarifying changes to the order granting the 10-day stay, just to update it. That's it. They're just technical corrections.
Any discussion on the changes that Tara is mentioning?
So the changes to page 20, and then the examples that are at the end of the manual are new examples. So that's what we're voting on now, to adopt those changes.
Yes.
Yeah.
Okay.
I move to adopt.
Thank you. Thank you.
Any comments from the public? Any other comments from the board? Call for the vote.
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bullard?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
And Dr. Nunez?
Yes.
Okay, motion carries.
Motion carries. Now we move on to agenda item number 5, which is labeled as review and discuss applications for appointments to the Multidisciplinary Advisory Committee. So since we have just...
Motion to move to election committee.
Thank you, Dr. Nunez. Is there a second on that? So I think, so since we did just establish the possibility of establishing an elections committee, that yes, we should go ahead and proceed with that. So I think Dr. Nunez was serious in making his motion on us to establish an elections committee.
I'll second. But I have a question.
Yes, go ahead.
So would that mean timing-wise, that the elections committee would meet, and then at the next meeting in February, we would be presented with a number of candidates?
Yes.
Jennifer, question also, did we receive any more applications than these?
So last night, I received an email from Stephen Seital, is that how you say that? Seital? Thank you. Who has requested to be considered for the RVT position. He was not included in the packet because, again, I just received the email last night. I think there is one thing that Dr. Waterhouse brought up offline that we do need to consider is when are we going to cut off accepting applications, because at some point we could continue getting these until the night before the board meeting, and we don't want anyone to cry foul. So we probably need to put a public statement on our website that the deadline to submit applications shall be
30 days before the board meeting?
Well, I don't know, would 30 days give you guys enough time to do what you need to do
30 days?
before the meeting?
I don't know, why not? Well,
Okay.
Oh, you mean?
Because you have to
30, so
do the phone
January.
interviews, yeah. We could do honor before November 30th, and that would give you December and
We
January.
need to notice the meeting about 15 days before.
Notice the meeting 10 days, we usually notice it about 2 weeks before, yeah.
And so maybe 45 days before.
Yeah, not more than that.
Okay,
45 days before the meeting.
okay. So I'll establish that deadline, and we will post that on the website 45 days prior to the next board meeting.
Well, prior to the board meeting, that the election is going to be held.
Right, that the interviews will be held, yeah.
It's a deadline for application.
Yeah.
Yes.
I'll accept that as part. Can I put that in my motion?
Sure.
Defer this to the election committee and also set a deadline of 45 days before the February meeting. The applications should be submitted.
So long as Kathy is.
That's fine.
And just for clarification, so for 2 DVM positions on the NDC, we have 4 applicants.
So far.
Any other questions?
Just, yeah.
Unless, Ethan, have you received any other applications to date? Okay.
Okay. Any comments from the public? Can you come forward, Nancy?
The RVT position will be voted on in February, but you're not going to be voting on the veterinary or public, are you? They're not. When are those positions available?
They term in June, so there's only the February meeting and the May meeting.
So you will be voting on the veterinarian and the public member as well as the RVT in February?
We can, yes. Yes.
That's what's been noticed.
Yes.
Yeah.
And the idea was to allow them to come to a meeting before they start to get some background material.
Okay, call for the vote.
Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
And Dr. Nunez?
Yes.
Okay.
Motion carries. Okay, moving on to agenda item number 6, proposed regulations. So Anne Marie will go through the status of the pending regulations and then move on to discussion and possible board action on each of the following regulatory proposals.
Okay, we're going to try to make this as painless as possible. So, quickly, I'd like to, instead of going through each one, I'll take questions, but I would like to give you an update. On the CPEI regulations, those are the regulations you adopted to allow the executive officer to accept surrenders of the license, and it gives me some purview that it also included if we were conducting a background check on an applicant, that we could require the individual to undergo a psychological or a medical evaluation if there was reasons to believe the individual was not fit to practice. That is still with the department under review, so we've submitted the notice package to the department. But those sections that say TBD in that column, there are actual section numbers. If you'd like to know what they are, they're 2003, 2017, and 2042. We're going to get into disciplinary guidelines in a minute, I think for the 5th or 6th time, and hopefully they will someday go away. And then animal rehab is before you today. Telehealth is before you today. RVT education, bottom of that page, we actually adopted the language at the July meeting, so if you could make that change. Fee increase on the next page was adopted at the July meeting. And as you know, today you will be looking at drug counseling, drug compounding, and emergency care for RVTs. The uniform standards for abuse is something that was put on hold. That language would have to be completely probably rewritten at this point. So as we make our way through our 10 reg packages, this one is not in the queue as of yet. It says in queue, but it's really, we need to go back and revisit language on this one. And then pending regulatory action, and actually the veterinary student exemption, we have to have a statutory change before we can make the change to 2027.5. Shelter medicine, as you know, is still in discussion, as is extended duty for RVTs. Any questions on? Yes.
You skipped the animal control training?
Yeah, so that's done as far as we're concerned. What has happened is the department, it had to ask for an extension from the Office of Administrative Law to complete their review. But that's a final rulemaking file, so our part is completely done.
That's almost done.
It just, OAL has to approve that, and we have to have this with OAL on or before the 21st of November. And then they only have 30 days. Then it would take effect at one of the effective dates, which are what, Ethan, for OAL? What are the effective dates?
We're going to ask for
immediate upon filing. So it would be effective immediately upon filing. So our part of that is done. Any other questions? Okay, let's move into under tab B, disciplinary guidelines. And I want to assure you that we've had enough people look at this enough times that I'm sure we'll find something wrong with them again, but for the purposes of getting something underway, we're going to cut it off where it is. There were a couple of more substantive changes that are outlined in your memo. One is notice to employees, and essentially we need to include that the employees that we expect the veterinarian or anybody else to notify, the employer to notify, are the individuals that we license. Licensees, registrants, and permit holders. So that was that amendment. Tolling of probation, the language was unclear, and I think what ended up happening is because of the number of iterations that we've gone through, some of the language was left in that should have been taken out before. And what we're really talking about is you are considered tolling if you are not working at least a minimum of 24 hours per week in California. So we clarified that's the intent. So the heavy lifting is really on the optional term 6, which is supervised practice. And there's a couple of things here that I would like the board to really consider. In our current disciplinary guidelines, we do not necessarily have a definition of direct supervision. We have definitions that talk about record review, and it's daily review, it's continuous, it's partial, but it really doesn't define direct supervision. So with the new guidelines, we want to make sure that we adequately define what direct supervision should mean. And the definition is there. You've seen it before. Everybody has agreed to this definition. However, the impractical part of this is that if you're expecting a supervisor to have physical presence 100% of the time while the respondent is practicing, and the qualifications to be a supervisor exclude anyone with a business relationship, a personal relationship, a familiar relationship, employee, partner, or associate. That means that you would hire someone that does nothing but supervise and pay that person $100,000 a year to stand there and not see patients. It's just not practical. And I don't foresee a judge being motivated to require that as a term when the financial consideration is such that I don't know how someone, unless they're independently wealthy, could comply with that term. My recommendation would be to strike associate if what we mean by associate is colleague. Therefore, it could allow someone that you work with, not as an employee, not as an employer, but as an associate, to supervise you for the purposes of your disciplinary term and condition.
Dr. Sullivan.
We may have to be a little careful with that definition because I think within the profession, associate usually means an employee that is in the practice.
So should we change that to colleague?
Well,
or how would you?
I think I was there when this was first brought up, and I'll tell you the situation, so we may need to change the definition completely. We had a case where the person was practicing as an individual. I think he was a relief veterinarian, but always alone. And from reading everything we could, the restricted amount of material we got on making a decision, we didn't know if he was competent or not. And so it was either revoke or let him keep working the way he was. And what we wanted to do is we wanted to allow him to continue to work and make a living because we weren't sure we needed to revoke, but we didn't want him practicing alone. So that's where we use the term direct supervision, which is totally incorrect by definition. So that's what our aim was to accomplish. And however we can word it, we just didn't have enough evidence to revoke, but we didn't want him working alone because we didn't know his competency.
Okay. So is the issue with supervising 100% of the time in physical presence, or do you think the issue is with who qualifies as a supervisor?
We were not concerned that it be done by an outside person coming in and like there is with record supervision. We just wanted him in a practice setting where he wasn't, where he or she, they're not on their own, where there is some, peer review every day that they're working.
So a suggestion may be, and I will tell you the Board of Pharmacy, in their definition of direct supervision, oops, we have a visitor.
Yes, he's a public member.
Yeah.
He wants to.
Oh, there goes the line. Okay, so the Board of Pharmacy does not define who qualifies as a supervisor. It just says that the board shall approve the supervisor for the respondent. So then it provides that flexibility. Now, an alternate to that would be the supervisor shall be independent with no current or prior business or personal relationship with the respondent, and the supervisor shall not be in a familiar relationship with the respondent, period. You take out employee, partner, or associate. So basically, it can't be a family member, and you can't have a financial relationship with.
But if they're working in the same practice, there may be a financial relationship.
It would remove if you're partners. I don't think you would want one partner supervising another.
Okay, but it could be an employer or supervising.
So is that okay?
Yeah.
Okay.
But Diane Sokoloff again, that potentially violates the words that you used before that, which said no current business relationship. Are you keeping current, or are you striking that?
Well, that's what's open to discussion. Current's new. That wasn't in the guidelines. That's not in the guidelines today. So the guidelines, the way they were written for this particular set of, was no prior business relationship.
I personally think that is a more workable definition, because I think you're going to be hard pressed, or a veterinarian is going to be hard pressed to find somebody that is going to just be willing to stand next to them,
right?
But not be involved in getting paid.
Does the when a respondent goes on probation, when they submit a supervisor, is that evaluated by our probation officer for the appropriateness? I mean, like, if a person who's been practicing for 20 years or so goes on probation and they assign one of their employees that has been out of vet school for 1 year, is that an appropriate supervisor? And would our probation officer have the ability to say that that's not an appropriate supervisor?
I think a supervisor has to be out 5 years, right? License in good standing and not and practice for 5 years.
Yeah.
I think it's subject to board's approval, board staff's approval. The supervisor is subject to board staff approval.
So it doesn't have to be exactly precise in the language that we're creating, because there is board approval for the appropriateness of the supervisor.
So the way the language is written on page 18, if you want to follow along, page 18 of your document, so behind the language, page 18 of the actual guidelines, it says, respondent shall submit to the board for its prior approval the name and qualifications of one or more proposed supervisors of respondent's choice. Each supervisor shall have been licensed in California and shall have held a valid California license for at least 5 years and not have ever been subject to any disciplinary action by the board. And then it goes on to further define who that person can be. You can completely strike that last sentence and leave it discretionary. And that is actually the way the Board of Pharmacy, how their supervision. Now, it does put the staff in a position to make decisions about the appropriateness of the relationship. So if, for example, someone submits a supervisor and staff says, okay, there is a financial conflict of interest between these two individuals in that the supervisor serves to benefit by allowing that respondent to practice independently because that respondent is making money for that supervisor, staff would deny that because there is a conflict of interest there. So it does give staff a lot of discretion to review the supervisor to make sure that it's an appropriate relationship and that the supervisor is not going to benefit in some way from the respondent practicing independently.
Well, maybe you could just, if you wanted to put some criteria in there, you might want to say the supervisor may not benefit.
You're going to have to benefit.
Yeah, I agree with that. If the person works in the same office, in some way you can infer that that person who's supervising is going to benefit by virtue of the fact that they're employed there. So, but it's okay for you to provide staff with discretion to make that determination because, you know, they might say, okay, obviously they're going to benefit. They're part of the same firm or company, but there's no other workable solution, and the supervisor has to sign off on it. I mean, they're going to have to say, I, you know, am qualified and will supervise and such like that. So it's just, you know, I guess my bottom line comment is that the way you had the definition might make it, you might handcuff you to.
And it is not a workable definition right now.
I don't think so. And I'm always, you know, as you can tell by what I've said before, I'm always in favor of less is more in terms of regulations and such like that, because it makes it more difficult, and there sometimes is a lot more litigation that's generated by virtue of the additional words that you include.
Candace, did you have any comments that you wanted to make with regard to this? You don't have to. I just wanted to make sure I didn't.
Can you come forward, Candace?
Candace Rainey, Veterinary Medical Board Enforcement Program Manager. I think you've covered it really well. As staff, we just struggle with, on one hand, we want to make sure that what we're doing is effectuating the desire of the board and the intent of the reason that the language was written the way it was written. And secondarily, we want to make sure that the terms that we're requiring of an individual serving a probationary period have value to them. And so if it's something that isn't really practical and we're not able to adequately monitor. It sounds great on paper, but then when it comes to actually ensuring that the probationer is actually doing that, it becomes difficult for staff to do that. That's kind of the situation that we're faced with supervised practice. We want to make sure that it's a value and that it's something that we can monitor and that we're doing it in accordance with what you'd like.
Dr. Sullivan.
This condition is used very rarely. Number one. Number two, maybe we could write something in here as to direct supervision in this context means that this individual is never practicing independently or alone.
It's defined.
I think we were originally going off the definition of direct supervision that we have in another section.
That's correct. So are you suggesting changing what's under the following terms of supervision on page 18, apply to licensed veterinarians only? And we have a direct supervision definition there that says, is defined as the physical presence of the supervisor 100% of the time respondent provides treatment or consultation to the animal patient.
Yeah, again, the problem with that is if this person has one supervisor, it means that they can only practice when that one person is there.
Right.
And that's not practical.
So how would you change that definition?
Direct supervision, as defined in this section, means that the individual on probation cannot practice as a solo practitioner. And maybe we need to define supervision as a within a group practice.
Well, then you would limit it to only applying direct supervision to someone that's within a group practice.
Yes, that's what we want.
So if you
we
have...
don't want them practicing alone.
Right.
And so, by alone, do we mean that there's other associates, or there has to be other associates there at the same time he's there?
Yes.
He can't work it by himself on that any day?
Yes.
So what if you have someone who's an independent practice owner who you put on probation and you say they have to be under direct supervision?
So that individual then would have to lease out his practice or something and go for a period of that particular part of the probation.
Okay. Work
in another practice. And again, we're talking about, I think, 1 or 2 cases I've seen in 6 years.
I don't think it's as infrequently as you think.
Right.
No, I don't think it's as infrequently as you think that we've applied direct supervision.
I've always struggled with the direct supervision with a sole practitioner. I wonder, I don't see how you can have 2 different, if you're in a group practice or so, I mean, it doesn't seem fair.
Right.
Yeah, legal, to equal protection or whatever, to have 2 different types based on your practice, because it's more problematic for the sole practitioner to become directly supervised than, but I don't understand how we could do it on the natural. I've never really understood it on a full direct supervision.
The problem is our other option then is to revoke the license.
Right.
Can I point out that the requirements with regard to who can and cannot supervise applies to both direct and indirect?
Yeah.
Right. Is there when the board did this way back when on the direct supervision, in addition to the 100%, I mean, instead of the 100% of the time being there, it is like a daily check of the records and the cases and the paperwork.
That's indirect supervision.
That's indirect
Yeah.
if it's daily.
Yeah.
Okay, I thought
Because
it was,
it's just review of the records.
Right.
So if you actually want someone to supervise the practice, the individual providing services, then it's beyond records, and that's the direct supervision definition.
Got it. Okay, thank you.
Dr. Nunez.
I mean, to address Dr. Sullivan's point, we do have categories of indirect supervision, because indirect supervision is just reviewing the records, and we have categories of that. Would it be feasible to have categories of direct supervision? Because if there's somebody that truly needs to be watched all the time, then that would be, 100%. But if you want an option to allow someone to have direct supervision, but in your scenario, not all the time, then can we have a categories of direct supervision, like we do indirect supervision?
Sure, but I don't think that accomplishes that case that I was referring to.
Well, the case you're referring to is that you want somebody who's under direct supervision, but he doesn't have to be there all the time. He is not allowed to be alone, but the supervisor doesn't have to be there all the time.
Right.
But so he can sort of pass on his supervisory role to somebody else in the practice.
I would like to hear what Bonnie has to say.
Yeah, I just had a couple of comments. We're seeing more and more of these, and so I am dealing with them. I will have to say that I didn't ever see one for 15 years, and lately I have 3 people. So I stay involved with my vets on probation, so my goal is to stay involved and make sure that they make it through. And this has been a struggle. This particular direct supervision 100% of the time is definitely a struggle the way it's written. I would strongly encourage you to eliminate the description, which begins with the supervisor shall be independent.
Yeah.
Because almost, and especially in some cultures, almost everybody has a personal relationship with his friends or the person that is in the area that's practicing. It becomes nearly impossible for these people to get a supervisor. Now, you know, I understand that if you order that, then that's what we're going to comply with, but it would make it much better if we could comply a little easier. And as far as the sole practitioners, you know, what I found in those cases is oftentimes they're willing to pay some amount of money, you know, to cut their hours down to the 24 hours so that they're still not tolling, and then that they're willing to pay somebody to come in and be at their sole practitioner facility for the amount of time, that 24 hours a week. So there are ways to work around that, or they go for a limited amount of time to work for somebody else who is willing to be their supervisor. But the critical issue here is the personal relationship, the prior relationship. And I think I would feel more comfortable if it was left up to the board's discretion once they get that application from the supervisor.
Thank you, Bonnie. And I'm guessing that Kurt has something to say.
Thank you, Madam Chair, members. I'll only come up, not only offer some of my experience with the medical board and kind of a human analog, and just to bring that, perhaps it'll help the board in their decision making, and not for any other reason. So in the medical board world, we have what's called practice monitors. And practice monitors are essentially, as Mr. Delmanayo described on page 18, certainly direct supervision, we would call that a practice monitor. Meaning somebody is not peering over the shoulder. It's ex post facto, after the fact. You're reviewing charts. Medical board also has one for billing, so you could have a billing or a practice monitor. So that's one thing. What is interesting to me as your formal counsel, I won't discuss any cases in closed session. That would be inappropriate. But generally speaking, just globally from my experiences, a licensee is bad in one area. Generally speaking, like they can't do whatever this one function is. So it seems like one of the things the board could do, it could tailor this to say, whenever you're doing that one thing, somebody else ought to be there because you don't seem to know how to do it right or properly. Or the medical board also has what they call the prohibited practice optional condition, which is during the term of probation, don't do that for whatever term, and then you would kind of gradually, maybe after a couple of years of probation, we'd allow you to do it when you're monitored. So again, not on the merits, I just wanted to say, generally speaking, finally, and then I will be quiet, if someone has to be supervised 100% of the time whenever they are practicing veterinary medicine, this is an old person thing. So from cradle to grave, to rolling morning, you see the first animal patient, to whatever scope of practice. The question would be, I think Dr. Sullivan so eloquently put it, what's that person doing with a license? Because if you have, like I said, if you have to be monitored for everything you do, there may be a corresponding diminishing value for the consumer protection, public perspective of what that person is doing with a license. So, thank you, members.
I'd like to respond to Kurt's comment. We do have a term on limitation on practice on page 17, where it does give the board the authority that say during probation, respondent is prohibited from practicing whatever. So we have that as a separate term, and we've used that in the past. I do, since we're talking about this term, I would like to make one suggestion that Dr. Waterhouse brought up, and I believe that Mrs. Lutz brought it up before. Subset B under limitation of practice says during probation, respondent is prohibited from basically practicing in a place that doesn't have a premises permit. It's not just during probation. That's every day, all the time. So if we just strike during probation, it basically reminds the respondent, you can't practice somewhere that doesn't have a premises permit. So let's say, for example, the respondent wanted to go into shelter medicine, and as we heard yesterday, there are shelters that don't have premises permits. They can't do that. So this just reminds the respondent that you're not allowed to practice in a facility that doesn't have a premises permit. But it really isn't during probation. A veterinarian should not be practicing veterinary medicine in a location that doesn't have a premises permit. So I would recommend striking during probation from that term.
Well, what about respondent?
What do you mean?
If a mobile veteran goes to somebody's house and practices veterinary medicine, the house doesn't have a premise permit.
The mobile veterinarian does. They have a mobile.
But how come it includes or mobile veterinary practice?
Because it's saying respondent is prohibited from practicing at a location or a mobile practice which doesn't have a premises permit. So,
okay.
You know what I'm saying?
Yep.
Some are brick and mortar facilities. Okay. So back to the supervision term on page 18.
I have a motion.
Okay.
I motion that we, where it says the supervisor shall be independent, and that's where we stop, and cross the rest of it out. And in regards to direct supervision and Dr. Sullivan's concerns, I appreciate the comments from Ms. Lutz saying that probationers do work around it, and she says that she makes it a point to have her clients get through probation, and if she's saying that they work around it, then they work around it, and that's good enough for me. So I'm not going to change anything there, and I would also include in my motion to eliminate 4B, because you said that that doesn't necessarily happen during probation.
Well, my suggestion is just limit the terminology that says during probation.
Okay.
Yeah.
So eliminate during probation.
Can I clarify? Your motion was to remove this entire sentence that starts with the supervisor shall be independent, right?
Right.
Okay. Thank
Oh,
you.
the whole sentence.
The whole
Okay.
sentence.
That's what I was going to ask. Yeah.
Okay. Thank you. It's still going to require that while the respondent is practicing, that they are supervised 100% of the time.
Correct.
If they're under direct supervision.
Correct.
Clarify.
Yes, Dr. Sullivan.
Can a probation person have more than one supervisor at a time?
Yes.
Okay.
And we've had that in the past, yes.
Okay.
And this, of course, still leaves the staff with the ability and actually responsibility to review and approve the supervisors.
Yes.
We've had a number of situations where we've approved more than one supervisor. There's one supervisor at a time that's responsible for accounting for that individual's practice. But if they notify us, they're going in, so that we know who's supervising at what point in time.
Okay, but my question is, if they're working in a practice, can they have two supervisors at the same time so that they can work more than one shift?
I don't know that we've been faced with that question.
I wouldn't see any reason why not. The intent of this is to make sure that they're supervised while they're practicing.
Right.
So it may be that then both supervisors have to fill out their monthly
supervision
evaluation form, but it wouldn't then in any way not be in concert with what we're trying to accomplish
I don't
the
think so,
provision of
and I don't
supervision.
think it would diminish the efficacy. of it.
Right,
Good.
right.
Okay, so we have a motion,
Second.
second. Any other questions from the board? Any questions from the public or comments?
Nancy Ehrlich, I would suggest that you consider changing the term from direct supervision and indirect supervision to some other words, rather than having separate definitions of direct supervision in this section and in other sections have different definitions of direct supervision. I think it's rather confusing for people who are trying to understand what these terms mean. So you could call it something like on-site supervision or full-time supervision or something that does not conflict with the definition of direct supervision in other contexts.
How about direct probationary supervision?
That would work.
But it is direct supervision.
But it's,
The veterinarian
Well-
is in the premises the entire time the person is
yeah, but that's not the definition of direct supervision for ancillary personnel. The animal has to be previously examined, and the job tasks have to be assigned by the veterinarian.
So before we get off track here, this is completely separate and apart from the Practice Act. This is a disciplinary guidelines that are imposed for discipline. And many boards have definitions that are separate and apart from what's in their Practice Act. This is for a completely different purpose. This is disciplinary.
I understand that. It's just that people know what the definition of direct supervision is in the context of how they're dealing with their employees. They may misunderstand the term if it's exactly the same term. If it's a slightly different term, people will understand it has a different meaning.
I don't think the
That's
general
just my
public,
suggestion.
I don't think the general public has a conflict with probationary terms if they're not enforced.
I don't have a problem with calling it probationary direct supervision and probationary indirect supervision. Unless legal counsel thinks that's too many words.
Yes.
I think that's redundant. It's redundant. This is probation.
This is all about.
This is the only time this is written is as a term of probation. It's not written anywhere else.
Then I don't change my motion. My motion
So if you're
stands.
under probation and you're under supervision, it's a probationary term.
Then I don't accept that amendment.
The one you almost made?
The one I almost made. Too many words.
Okay, we have a motion and a second. Any other comments from the public? Comments from the board? Call for the vote?
Sure. Dr. Waterhouse?
Yes.
Dr. Sullivan?
Yes.
Kathy Bowler?
Yes.
Jennifer Laredo?
Yes.
Dr. Nolan?
Yes.
And Dr. Nunez?
Yes.
Thank you. Okay, let's continue on. The other, we would consider substantial changes if we go back to the memo. These are a little less, I think, arduous than the first one. Yeah. So page 2 of the memo goes through optional term 14 for medical evaluations. And unfortunately, we changed this in one place and didn't change it under term 14. We cannot do an automatic suspension without due process, but we can require that a respondent cease practice until their treating physician or psychologist or psychiatrist says that they're fit to practice. So we need to make sure we change automatic suspension to cease practice. Under optional term 18, abstain from controlled substances, we specifically, on page 22, needed to change this language because, one, we had a reference to an outdated statute, and two, Tara had some very good suggestions for this term, that respondent is restricted from taking prescription drugs unless the drug is prescribed to him and her by a licensed practitioner for a bona fide illness, and it's necessary. It's a necessary part of respondent's treatment. So this just makes it clear to the respondent that if they're on probation, they can't then start taking other medications that were not prescribed and weren't prescribed for a very specific condition.
I thought that was already in there.
It was just worded differently. It was in there. It was worded differently, and then we had a reference to an outdated statute.
Okay.
And then finally, oh, did you want to comment?
I have a little problem, Bonnie Lutz again. I have a little problem with necessary. I can see that that might be problematic. I completely understand that people on probation should not take drugs unless they're prescribed by a doctor, and we've been successful in the past at just sending the prescriptions to the board, and we've never had any trouble. But I'm really concerned about this necessary part, because I don't know who's going to be determining whether it's a necessary part. I mean, because if the physician prescribes it, I think we can assume it's a necessary part of the treatment.
So the actual language reads as follows. If you want to follow along on page 22. Respondent shall completely abstain from the personal use or possession of controlled substances as defined in, and then we had to update that section, it's Business and Profession Code section 4021, and dangerous drugs as defined in Business and Professions Code section 4022. So controlled substances are different than just prescription drugs. Except for medication lawfully prescribed to respondent by a licensed practitioner for a bona fide illness. So it doesn't say necessary in the actual language. Upon request of the board or its designee, respondent shall provide documentation from the licensed practitioner that the prescription for the drug was legitimately issued and is a necessary part of the respondent's treatment. So your issue is necessary part of the respondent's treatment?
Yes, I mean, that's really vague. I mean, I don't know who determines.
I don't know if it changes it if we say and is part of the respondent's treatment.
Isn't it the licensed practitioner that's making that call?
Right, it is.
So at the end of the day, it is the doctor that is.
Right. It's not us making that call.
Anyone on the board.
No.
Okay, so then this is not, we go ahead and we still submit the prescriptions, and then if the board decides they want to ask us more questions,
right,
then you will contact us and say,
right,
we need something from the doctor indicating this. Okay.
Exactly.
Okay.
Yeah.
It's Candace reading the sides.
Okay, so the final piece to all of this, which is actually what puts these guidelines into regulation. They're incorporated by reference in that document that you have prior to the guidelines, which is the document that says this is the language. There's a couple of underlines, a couple of formatting changes missing in that document, but for the purposes of the public, I will let you know what they are. The Veterinary Medical Board Disciplinary Guidelines, October 2017, the date should be underlined. And then there's some authority and reference citations that need to be underlined. So I'm going to distribute these to you just so you have the underlined copies. And then there are additional copies for the public if they want to look at it. It doesn't change any of the text. There's just a couple of underlined words that we're missing.
And these are different than what we have.
Yeah, all it does is underline a couple of areas of the text that weren't underlined.
Other sections.
I no longer want to adopt this. Okay, so again, what we covered today was the substantial changes to the language. There are technical, non-substantial language or changes to the language that were either formatting or editorial, where we had to make sure the grammar of the text read correctly. The substantial changes, I'll go over one more time. Notice to employees, tolling of probation, minimum of 24 hours. We voted on the supervised practice changes. Medical evaluation under optional term 14, we needed to change the terminology from automatic suspension to cease practice. Optional term 18, we just discussed the abstention from controlled substances, and then finally the new language that was distributed that has the underlying changes in it. And that would complete the substantial changes in the document. And then Tara, do you have anything else that you wanted to add?
No, I don't. You covered it.
Okay. Yes.
Motion to adopt.
Yes, you're just a motion machine today.
Yes, and I'll say.
Okay, so the motion itself needs to be very
I can read
explicit.
it. Sorry.
Okay, you got it.
I have it. Yep. Sorry. Okay, so since we are motioning, we are making a motion to adopt a regulation that will go through the regulatory process. Bear with me because there's some specific language that I must read, and that would be the motion that the board is making, and I'm going to pull it out momentarily. Here we go. Okay, the motion shall be as follows. This motion is to approve the proposed regulatory changes as modified. Direct the executive officer to take all steps necessary to initiate the rulemaking process, and authorize the executive officer to make any technical or non-substantive changes to the rulemaking package. Notice this proposed text for a 45-day public comment period, and if no adverse comments are received during the 45-day public comment period and no hearing is requested, adopt the proposed regulatory changes as amended.
Second.
Jesus, so efficient. Wow.
Okay, we have a motion and a second.
Hey, that's all Tara.
Any other comments from the
gonna
board?
say that.
Any comments from the public? Call for the vote?
Okay, it was Kathy.
Yes.
Kathy, you seconded?
Kathy seconded.
Okay. And here we go. Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
I'm going to go out of order here. Kathy Bowler.
Yes.
Jennifer Laredo.
Yes.
Dr. Nolan.
Yes.
And Dr. Nunez.
Yes.
Motion carries.
Motion carries.
Can I ask, what's the next step here? on this?
We actually prepared this package to go to the Department of Consumer Affairs to initiate the pre-review. If there are no substantive changes, it will go to the public for the 45-day comment period.
And then it
Goes through the whole process.
Yeah.
The Department of Finance would review it. Yeah, you know.
Can I ask a quick question?
Yes.
It has nothing to do with disciplinary guidelines, but it made me thinking, under tolling of probation, it's defined that you have to work 24 hours per week to be actively engaged in the practice of veterinary medicine. Does that apply to a person who has an active license, who's not on probation, just has a license?
No.
They don't have to have that minimum.
Right.
So they can work 1 hour a year and still be a licensed veterinarian.
Yep.
Yes. Okay, moving on to the next possible board action on regs regarding drug compounding.
Okay, so all of this is actually included under 6B, and there's some yellow dividers. So if you find your way to the next yellow divider, you will be reviewing the drug compounding language. I promise you at the next board meeting, we will have titles on the top of these documents to make them easier for you to find. But this starts with Article 11, section CCR section 2090. I think perhaps open it up for discussion. This was a recommendation from the MDC before the board.
Yes, I have a question.
Sure.
On the first page, under it's under B. B, compounding does not include the reconstitution of a drug pursuant to a manufacturer's directions, obviously. Nor does it include the sole act of tablet splitting, crushing, capsule opening, or the addition of flavoring agents. I think it should. So I know that
We
language
took
is.
that from the human side.
Yes. And I know I have seen problems with that. I see problems continuing with that.
with tablet crushing.
And adding in liquid, and the owners have gone to the emergency clinic or another veterinary hospital somewhere, and they bring this in, and they've been using it for a while, and I look at it, and you can see the pieces of the tablet at the bottom. And so unfortunately, I have to tell them just to throw it out, it's worthless.
Well, then that,
So I don't know how that.
I would say that is a problem with the
Quality control,
process
yes.
of doing it. The fact that you're simply adding a flavoring agent to enhance palatability is not compounding. So I think we have to stay with the definition. Anything that we do, if we do it wrongly,
Yes.
is a problem.
Yes. Dr. Miller.
Grant Miller, California Veterinary Medical Association. Just as a point of clarification, Dr. Waterhouse, the exclusions for compounding per the pharmacy language that we're reading here include the sole act. So in pharmacy language, you may crush a pill, period. You may melt a pill, period. You may add a flavoring agent to an existing powder. You may not crush and add a flavoring agent. It's the sole act.
Sole act, yeah.
Thank you.
Then you're compounding.
Thank you.
Yeah, interesting. Yeah. Dr. Nunez.
You know, and I appreciate the fact, listening to the to the MDC meetings where a lot of this has been hashed out, that a lot of this language came from working with the Board of Pharmacy, who I really have to rely on as the experts in compounding pharmacies. So I'm pleased with how this process developed to get this language before us.
I also had a question under 2024. Sorry, no, that wasn't it. Sorry, no. I answered my own question on that one. Okay. Any comments from anybody?
I only had a question about that one highlighted section on the, it's not numbered, but I guess it's the page 3, part that's highlighted. It says the expiration date may be extended if the product's integrity, potency, and quality are measurable and demonstrable by by whose definition of that?
Dr. Sullivan.
Okay, and when we're talking to the pharmacy board, and we're talking about quality assurance, we're talking about expiration dates, and we kind of explained to them that our compounding is really, really pretty simple. We got into this discussion, and we got into discussion of the expiration dates, and one of the comments I said is that we've been doing this for 40 years, and in my opinion, that has stood the test of time. And their comment was, that's what you need to document. You need to document that you've been doing this, or you've got examples of this combination or compounding has been used, and it's effective. One example we gave was sodium bromide. Compounding that, we can measure the bromide levels in the in the blood test 30 days out, 60 days out. If it's a therapeutic dose, it's being effective. So it's that kind of documentation.
Okay, because reading a lot of the Board of Pharmacy's regulations, they talk a lot about what you have to do to prove something that's measurable.
And that's
but that's not. This wouldn't make it that stringent.
At the beginning of the discussion,
okay.
At the beginning of the discussion, that's what they were leaning on. And with examples, John and I gave them a number of examples, and they saw that, yes, this is pretty simplistic, and it's been going on for a while. We're not expanding the scope of practice. We're documented or putting into regulation what we've been doing. And so it was a good, very good discussion. But it doesn't allow you to grab something out of the air and say, okay, I'm experimenting and I'm doing this on my own, unless you've got documentation.
That would be my concern.
Yes.
But you think that this language is strong enough to not allow that?
Well, what makes it strong is the fact that you have to have documentation. If you're compounding sodium bromide, you've got to have documentation as to how you're doing it, who's doing it, how they're trained. And when one of our board members or one of our examiners goes in and asks, "Are you compounding?" and the person says yes, let me see your formulary, or I think we call it procedural manual, and it's got to be there in writing.
Okay.
And we, and I think the CVMA, when this all gets through, will put out some information on how to cook with it, so that it's very straightforward. Especially the quality assurance does look difficult and complicated, but it's very simple paperwork to back up what you're doing.
Okay.
Dr. Nolan.
I would just assume that at some point then the inspectors that we train will have a little more training on this, so they're going to be capable of looking at those quality assurance manuals and the compounding. Okay, and the second is, do you feel like we need to specify which board? Because you just list board. I didn't recall seeing it specified earlier, and then you do mention the State Board of Pharmacy, but should we say Veterinary Medical Board, or is that not necessary?
No, because it's our regulations, but anywhere where you're referring to someone other than your board, then you would specify which board.
That's why theirs is specified.
Yeah.
And it is stated in 2096 on the last page.
Oh, there it is. Okay.
Oh, when we're talking about the enforcement, yeah.
I just wanted to make sure that everything was.
Yes, Nancy?
While Nancy's coming up, I just want to make one note on, in 2096, on the very last page, it says California State Board of Pharmacy and the California Veterinary Medical Board. We just need to take out California in front of Veterinary Medical Board.
Oh.
And then that would be consistent with the mention in B, subdivision B.
Gotcha.
So it would be moving this as revised.
It would be what? I'm sorry.
If there's a motion, it would be moving it as revised.
Yeah.
Just to make a minor change.
Okay.
Can I ask a question? I'm confused. In A, are you saying the California State Board of Pharmacy shall have the authority as opposed to can the California Veterinary Medical Board?
We're trying to give them
both.
Both boards. We're trying to give the both boards the authority to go in and make sure that this compounding is done correctly.
So both boards have the ability to inspect, is my question, on veterinary premises?
Yeah.
Okay.
Yeah. Would
Oh,
it accomplish the same thing if we just put California on B, the California Veterinary Medical Board?
No, because technically pursuant to the statute, it's Veterinary Medical Board.
Turned to what statute?
Ours.
What were named?
All right, okay.
Nancy?
Okay, in 2092, there's two mentions of registered veterinary technician, one requiring the initials of the veterinary technician, and one, the supervisor has to document the training of the registered veterinary technician, but there's nowhere where it mentions the level of supervision of the registered veterinary technician. I think you need to mention whether it's direct or indirect supervision.
Where are you referring? You said there's two sections?
We can't hear the back.
Yes, can you?
I can't find where it says what level of supervision for the registered veterinary technician. If it is there somewhere, I didn't find it. So if it isn't there, it should be. And assume whatever level of supervision it is should also be put into Section 2036, which is the Animal Health Care Task for Registered Veterinary Technicians.
Okay, Dr. Sullivan.
It is.
Under definition
Yeah.
of compounding, it says that compounding means any of the following activities performed in a registered veterinary premises by a licensed veterinarian that has established the DCPR for the patients or
Okay, there
a
it is.
registered
Okay,
veterinary
direct or
technician
indirect.
under direct
So
or
then it should be
indirect.
put into 2036 under indirect supervision for an RVT.
It doesn't have to be if it's specified here.
No, it doesn't have to be, but since we are outlining all the other job tasks that registered veterinary technicians may do under direct or indirect when they're specified, it should be there so that people know that it's there. I mean, why would you leave this one out when you delineate all the others?
Jennifer?
That's actually something I brought up in my RVT report at the last meeting, that when we came to that, we could discuss adding that to 2036.
Dr. Sullivan?
After looking at this probably 105 times, I still, in reading it this time, I noticed under definitions of 2090 under C, expiration date, I find that the part in that definition that says, after which administration of compounded drug preparation shall not begin, I find that verbiage a little cumbersome.
Which verbiage?
The term, after which administration of compounded drug preparation shall not begin.
Oh, gotcha, okay. Shall
Maybe
not commence?
Shall not be used, or shall not be dispensed, or, yeah.
Okay.
I mean,
Oh, yeah.
After which administration?
or after which the compounded drug should be destroyed or
You know what? When I read, I put a note here on the side, it almost is like a best if used by date.
Yeah.
Which means that it may still be good. I mean, that's why I thought the same thing too. It's almost like best if used by. You can start it, like if you have a 14-day course of treatment and the drug's going to expire in 7 days, those last 7 days, does it mean that the drug shouldn't be used?
Is that sentence even necessary? Because if you read it with expiration date means the date or date and time determined from the date the preparation is compounded, and then if you strike out after which administration of comp shall not begin, you just say which is compounded and the preparation shall not be dispensed, administered, or yeah.
Yeah, let's do that.
Okay. Okay.
Can you say what you just
Yeah,
said?
let me make the change.
Yes, that's it.
Okay, it's compounded and preparation shall not be dispensed, stored, other than for quarantine. Okay, dispensed or stored. Okay. You want me to read that? Okay. Dispensed, administered, or stored. Okay. So it would read expiration date means the date or date and time determined from the date the preparation is compounded, and the preparation shall not be dispensed, administered, or stored other than for quarantine purposes.
Or that instead of and.
I'm sorry?
The preparation is compounded, that the preparation shall not be dispensed.
Okay.
Well, I actually think you're trying to conflate some things that might not really work as one sentence, because I don't think that, I mean, I like what you said, Anne Marie, in terms of fixing the second part, because after which didn't make sense, but I think your point is almost a separate sentence. I just don't see it going together from the first part of the sentence to what you said, unless I'm reading it wrong.
Read it again. Okay. We'll read it again.
Expiration date means the date or date and time determined from the date the preparation is compounded, and that the preparation shall not be dispensed, administered, or stored other than for quarantine purposes.
So the expiration date means the date the preparation shall not be, that's what it means? I mean, is that really what it means?
No, it means the date or date and time determined from the date the preparation is compounded.
Period.
That the preparation shall not be dispensed.
I'm just not, it's probably me, I'm just not following that.
Oh,
I am.
I think the question is really, can you continue to administer it if you've already started? That's the way I'm looking at this. So is it true that after the expiration date, and I think Dr. Nunes, I think you were addressing that. I mean, once it's already been started, can you continue to administer it after the expiration date?
Dr. Nunez.
I'm going to say something that I believe is going to be very enlightening.
As always.
When I read this, I thought it was odd, as Dr. Sullivan pointed out. So the expiration date, et cetera, but then on the third page, it says the expiration date may be extended, provided the integrity, potency, and quality are measurable and demonstrable.
Right.
So any questions that I had that this medicine was going to be ineffective, as long as you can prove that it's effective in a measurable and demonstrable way, then I think everything's covered.
Right. I think the application of it, you're right. It clarifies that if you have some documented evidence by virtue of your history of use, that it can be extended beyond the date. That's covered elsewhere. I think people are struggling with the awkwardness of the language here.
And I didn't struggle with it because it was somewhat addressed in another part of this regulation. That wasn't that enlightening?
Very.
What about expiration date of the preparation shall not be dispensed or stored other than quantity purpose based upon the date determined from the date of the preparation is compounded?
I would only say that I think we're really trying to make sure that we've got a clear definition for pharmacy, because they were using a different term, and so we want to show, you know, our good faith effort of establishing a definition for our new term of expiration date. So at some level, we need to keep it looking like a definition. I think the Anne Marie's revisions, you know, narrow it so it gets a little bit more focused and meaningful.
And the reason we did that is on the human side, they use beyond use date, but all of our software says expiration date, and there was no way we're going to get labels reprinted for that small market, so we stayed with expiration date. I'm fine with Anne Marie's definition.
Yes, John.
And thank you, Dick. That's John Klingborg, MDC Chair. That's part of what I was wanting to clarify. The reason why we have this language that seems a little peculiar is because of the beyond use date designation on the human pharmacy side, which does allow you to start administering something within 1 hour, a sterile compounded drug. And the recognition is that it may take longer than 1 hour for that drug to find its way into the body. It may be part of an IV drip or something like that. It could take 24 hours, but it must begin within 1 hour. And so that's beyond use date. Again, I don't know that we want to get too far afield of the definitions that are on the human pharmacy side, but we're trying to find some language like expiration date with which we are more comfortable and familiar at the same time. So I don't know that this is broken. It feels a little weird to us. I think the Board of Pharmacy would understand this language well because they know it. It's their language.
So are you proposing that it's fine the way it is without any changes?
I don't think it's broken. Yes, I'm proposing it's fine the way it is. If you feel that there's a lack of clarity there or confusion, then we need to make sure we clarify that. But if we have a sterile compounded product that, again, that by the way that it's done on the human side needs to be administered within, the beginning of administration is within 1 hour. We're just trying to mesh with the regs that they live with. So I believe that it is fine.
I agree with you.
Okay.
Thank you for that explanation.
Can I make a motion now?
Oh, yes, please.
I would like, and I think to have fancy
Oh, yeah,
words.
yeah.
According to the fancy words that we adopt the proposed language with the exception of the California in front of it.
Okay, I'll go ahead and read the motion.
So we didn't change it?
Yes. So the motion is to approve as amended the proposed regulatory changes, direct the executive officer to take all steps necessary to initiate the rulemaking process, authorize the executive officer to make any technical or non-substantive changes to the rulemaking package, notice the proposed text for a 45-day comment period, and if no adverse comments are received during the comment period and no hearing is requested, adopt the proposed regulatory changes as modified. For clarification, this does not include any changes to 2090 subdivision C. It will remain as written.
Okay, we have a motion. We have a second?
I second it.
You seconded, okay, good. Any other comments? Any comments from the public? Bonnie?
I actually had comments about a different section. I had some comments about 2095. One of my concerns was...
I'm sorry, which?
2095. My concern was 6 lines up from the bottom where it says, nothing in this section shall be construed to prohibit a client or client's representative from accessing records of the animal patient, and that flies in the face of our regulations, which, well, the client is entitled to a summary. The client's not entitled to the records. So my concern is, does this change that? Because under the applicable regulation, which we deal with all the time, the client can get a summary. The client in California is not entitled to the record. So I'm concerned that this will be confusing and that then attorneys, client representatives, or the client will assume now that they can get a copy of that record in, which is not in what the regulation says.
Does this necessarily mean, when they say accessing the record, does that necessarily mean that the record cannot be provided in a summary form?
No, well, this is specific to the records which documents and assesses the medications quality assurance. It's specific to the records on compounding, and this is consistent with pharmacy law. So perhaps we need to make that more clear. It's not the entire animal's medical record. It's the records as related to the compounding of the drug.
That would really help, because I can just see the attorneys who are the client representatives looking at this and expecting to be able to get 10 years worth of records.
Could we reference that section of medical records?
Yeah. You mean this, which section of the medical record?
Where it says that we can provide a summary?
The summary.
We could say accessing records pursuant to of the animal patient, yeah.
But the part of the record where it delineates exactly how that drug was compounded, and how many mils of this and how many mils of that, for instance, that would still be in the summary, correct?
Could be, yeah. Or you could provide him the actual record.
What they don't have access to is the quality assurance records within the clinic.
Right.
The board has access to it, but not the client.
So just for clarity, if we say, let me look it up so that we can include it in the motion. It would be pursuant to 2032.3B.
Okay.
So, Dr. Nolan, would you like to change your motion to include?
I did just want to, I think that we've gotten the clarity there, but we've got two different records. We've got quality assurance records, which are privileged and are not available to the client.
Right.
And then we have the normal medical records that are available in the typical fashion, summary fashion. But my understanding is that the quality assurance records or quality control, those are going to be all private and internal. I don't know that we have to document within the medical record the recipe for the compounded drug. And so, you know, we've got a number of different things in play here, but quality assurance stuff is all within the practice and it's not discoverable.
But the formulation would be discoverable.
Yeah.
It would be.
But not the internal evaluation or quality assurance. You're right.
So this is a point of clarity to try to make sure we understand the last mention of records. I'm willing to add that to my motion.
Okay. Thank you.
I don't know for sure. I don't have my book of terms. So that's the right one.
Do you want to look it up?
No, just assuming it's the right one.
Yeah, 2032.3B.
And you accept that?
Okay.
Okay. Call for the vote?
Dr. Waterhouse.
Yes.
Dr. Sullivan.
Yes.
Jennifer Laredo.
Yes.
Kathy Bullard.
Yes.
Dr. Nolan.
Yes.
And Dr. Nunez.
Yes.
Okay.
Motion carries. So we will break for 1 hour for lunch and meet back here at 1:30. Thank you.